At a first court appearance in a $50 million rape and abuse lawsuit, Shannon Sharpe's legal counsel showed up, but the plaintiff's legal team? Not so much. The surprise no-show raises some serious questions about the future of a case already loaded with explosive allegations and high-stakes drama. We are going to break down how all of this unfolded, what could come next in a lawsuit that is tangled in celebrity controversy, and what we should be thinking about as we talk next moves for Shannon Sharpe. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. The first hearing in the explosive $50 million civil lawsuit against Pro Football Hall of Famer Shannon Sharpe took an unexpected twist on July 9th, 2025, and that is when apparently no attorney representing the plaintiff showed up at the Clark County District Court out in Nevada. Unusual, potentially damaging, we're going to discuss that, but you have to start asking questions about the direction, maybe the stability of a lawsuit that's delivered more than its fair share of surprises since first grabbing the headlines several months ago. Now, before we dive into the latest developments, got to do a little bit of a rewind here. So the lawsuit that was filed on April 20th, 2025 by prominent Houston attorney Tony Buzbee on behalf of an anonymous woman in her 20s contains graphic allegations against the former NFL tight end turned media superstar Shannon Sharpe. And the complaint alleges that Sharpe engaged in what is essentially a pattern of sexual violence and psychological abuse during what began as a consensual relationship with the plaintiff, who, by the way, is apparently more than 30 years his junior. According to court documents, the plaintiff met Sharpe at a Los Angeles gym when she was just 19 years old, and the lawsuit claims that Sharpe, quote, incessantly pursued the young woman, demanding her phone number, eventually asking her to visit his home, and most disturbingly, possibly, is the filing alleges that Sharpe required this woman to sign an NDA, a non-disclosure agreement, before their first meetings, although this request is something she repeatedly refused. Now, the relationship, according to her, allegedly turned abusive, verbally screaming at or berating her, violent sexual episodes, control. But the most graphic allegation describes Sharpe allegedly sexually assaulting and raping her, including ignoring her screams and refusing to wear a condom. Now, the lawsuit also claims that Sharpe secretly recorded their intimate encounters, shared the videos without her consent. But maybe the most chilling aspect of this are the alleged threats that were captured in audio recordings that were released by Tony Buzbee. In fact, in one clip, a voice identified as Sharpe's can be heard saying, "If you say that word one more time, I'm going to bleep and choke the bleep out of you when I see you." Now, the woman, allegedly the plaintiff in the case, then can be heard saying she doesn't want that, while the voice resembling Sharpe responds, "Yes, you do. I don't think you have a choice in the matter." So it becomes a question, do you take that literally? Or I think the other way of looking at it from the defense's point of view would be this is role-playing of some kind. Well, Sharpe has adamantly denied all the allegations through his attorney, or one of his attorneys, Lanny Davis, who called the lawsuit, quote, a classic definition of blackmail. And the former NFL star took to Instagram shortly after the lawsuit became public, posting a video where he called the allegations, quote, a shakedown, promised to fight back aggressively, quote, what they're getting is sued, Sharpe declared in the since-deleted post. And he even suggested that Buzbee planned to release edited portions of a sex tape and challenged him to release the full recording.
This is a shakedown. That video should actually be 10 minutes or so. Hey, Tony, instead of releasing your edit, put the whole video out. I don't have it, or I would myself. You know what happened, and you're trying to manipulate the media. The encounter in question took place during the day at her invitation, and now that appears to be a deliberate setup. What they're getting is sued for defamation and trying to take me down. My career is all about real talk and honesty. I know my family and fans know exactly what this is about, and I'm going to be out there telling you whatever I need to say, just like I always do. I love all you guys. Thanks.
So now let's talk a little law here. So typically, defendants in lawsuits, in federal lawsuits, are given 21 days to respond with an answer once they're provided the summons and complaint. An answer being where they go through the allegations in the complaint line by line, paragraph by paragraph, and they admit, deny, say they don't have enough information. It's a response. And, you know, what's interesting about this is, according to reporting from the New York Post, it doesn't seem that Sharpe has legally responded as of yet can't really confirm that, but that's what the reporting seems to suggest. And we'll talk more about that when we get into it. But first, I want to bring on a special guest to help me break down the latest, including what happened in this hearing. I am joined by sports attorney Dan Lust, professor, New York Law School. Good to see you, my friend. Thanks for taking the time.
Always good to see you, Jesse. Happy to help.
Thanks. So what are the typical timelines for a high-profile civil lawsuit like this to progress from filing to resolution? Am I right that it's 21 days to respond? I mean, is it typical? How does it work for people who don't know how civil lawsuits typically work?
Yeah, I mean, this is like law school basics, right? We're talking about how a lawsuit started, right? There's the filing of the complaint, there's the service of the complaint. Certainly depends on what court you're in, what state you're in, but generally, right, once you are served with the complaint, sometimes you have 21 days, sometimes you add some more time if it's personal service versus a mailing, right? But either way, once a commencement papers are started, you have a set amount of days to respond to that. Otherwise, you risk being held in default, either by plaintiff's counsel's motion or sometimes, right, particularly in federal court, something like sua sponte, right? And that's a fun Latin term where the judge themselves decides to hold you in default. So it is somewhat odd, and I know, Jesse, there's probably more questions than answers. We get to this hearing, and we have no response from defendant, but we also have a no-show from plaintiff. So it's not really your typical setting how we're starting this debate. In this case, a very high-profile case, that I wouldn't say this is following the normal playbook, so to speak.
By the way, as we're talking about a big lawsuit like this, how could I not talk about experts in the litigation field? Morgan & Morgan. This is America's largest injury law firm, our sponsor. In the past few months, Morgan & Morgan secured a $9.3 million verdict for a car crash victim in Florida, a $5.6 million verdict for another car accident victim in Atlanta, and not to mention $1.8 million in Kentucky after insurance offered them a mere $5,000 in that case. And even if you think your case isn't worth millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks, and everything from signing contracts to uploading documents to talking to your legal team, it can all be done through the phone. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar. Yeah, I'll get into the hearing and what happened or didn't happen in a second, because I think it's interesting that apparently a lawyer didn't show up and why that might have happened. But going back to this, if it's real, if the reporting's true, and this was filed in April, I mean, we're already in July. We would say 21 days, 30 days. I didn't see anything. Yeah, I didn't see anything about him getting some sort of extension. He might have. But what would be the reason to not prepare an answer? And would there be a situation where the court says, we're going to allow the case to go forward? You're not in default. Just file an answer as soon as you can. I mean, it just seems strange that based on the reporting, I think it was from the New York Post a few days ago, that they said there was no legal response yet. Can you give any insight into that?
Yeah, I mean, this is, I tell my clients, right, like the wheels of justice turn very slowly, and sometimes you don't really have an answer, right? And sometimes just, hey, what is stopping these attorneys from just kind of pushing the case out indefinitely? So behind the scenes, judges are graded on their own rubrics about how quickly they're adjudicating cases. So no judge is in the business of just allowing a case to be we'll say extended indefinitely. And judges, part of their job, in addition to getting a decision on the merits or pushing the parties toward a settlement, is to push the parties in some direction and not just kind of lay out there. And Jesse, just I guess like strategically, when Lanny Davis came onto the case, he came in very aggressively. And I know we spent a lot of time in our last conversation talking about making public of certain settlement negotiations. But Lanny Davis also said that Sharpe was going to go on the aggressive with his own defamation case. So, I just from the initial posturing of the case, Sharpe is not taking an aggressive standpoint. Quite the contrary. He's just kind of playing wait and see, I guess, for lack of a better term. So, if people have questions as to why Sharpe and his legal team, and I think there's some new lawyers involved now, it's certainly a changing of the strategy, which on day one was let's go 100 miles per hour, let's go on the offensive. And now when you don't really file an answer, it's safe to say you're not even playing defense. You're just kind of doing nothing.
Is that Typical in the sense, like, you could say, okay, well, there's a change in circumstances. We're going to come off aggressive first, but, things can change. It's not necessarily that there was a mistake made with that comment. I mean, there could be a situation where you say a thing one day and then there's a change in circumstances the next, right? I mean, I hear exactly what you're saying. And I believe Lonnie Davis had talked about how Shannon Sharpe had rejected a settlement offer. And like you said, we talked about that. Was that wise to make that public? But I guess there could be maybe just a reason why there seems to be a change.
I mean, I'll give you my best guess, right? So it looks like Lanny Davis, for we'll say best case scenario, is one of now a number of lawyers involved on Sharpe's side. So it could be, right, you have new representation, they want to slow things down, they want to just change the gear, right? The other, just I want to throw this out there, and again, you and I are trying to make sense of what is a pretty much a barren docket at this point. Why, and certainly on the plaintiff side, people are not, this is not a foreign concept. Plaintiff's attorneys in a case like this will generally work off of some contingency. So they'll get paid, assuming plaintiff side wins, right? They're not generally working off of a billable hour system. Very different on the defense side, where defense counsel are getting paid by the hour, right? Billable hours. So if Sharpe's side were to take an aggressive standpoint on a defense case, for the most part, again, we're not aware of what Sharpe's arrangement is here, but you'd be paying attorneys by the hour to take an aggressive standpoint on that defense. Now, hypothetically, Jesse, let's say the parties, since you and I last spoke, right, at the end of April, beginning of May, whenever that was, let's say the parties have made some additional traction towards settlement. And as Sharpe's lawyer, Davis, said, at one point they were making some progress. So let's say over the last 2 months or so, they've made some progress. That would be a reason to slow down these court proceedings. So Sharpe's side is not racking up the legal hours, speeding a case along in terms of starting the process of discovery and getting a deposition schedule. And maybe they're having some real substantive momentum of moving this forward. That's also a plausible explanation. And it's not just changing of the guard. It could be some progress is being made behind the scenes that you and I wouldn't see.
Well, let's talk about it, because let's go to this hearing. So Judge Anna Albertson presided over what should have been a routine meeting for the civil suit that is obviously made national headlines since it was filed in April. But instead, the hearing became notable for who wasn't there. Any legal representation for the anonymous female plaintiff accusing the 57-year-old media personality of sexual assault, battery, intentional infliction of emotional distress. Only one attorney appeared in that downtown Las Vegas courtroom. There was Robert DeMarco, who's representing Sharpe's legal team, which, by the way, is primarily composed of New York-based lawyers. And DeMarco explained to Judge Albertson that other attorneys on Sharpe's team, they were currently handling cases out of state, so he was there. Now, the defense requested a 45-day extension to review the case's progress, which the judge granted, despite, and this was interesting, despite expressing surprise that Sharpe's team wasn't pushing for a quicker resolution, meaning like a settlement. So the next hearing is now scheduled for September 3rd. Dan, a lot to make here. How on earth is it possible that an attorney for the plaintiff doesn't show up? How unusual is that? Is there a significant reason why that would happen? I can't imagine it's strategic. You got to show up to court. What's going on here? Does it say, wait a second, maybe this, I mentioned the word stability. Does it give you questions about the stability of this case?
Stability, viability. I mean, we can say that, but again, let's just play it like if a plaintiff's attorney doesn't show up to a case that they've commenced, right? They've made these big public statements, the case is out there, and you just no-show. And I understand maybe the attorneys are out of town, whatever else. There is, at least as far as I can tell, no tactical or strategic advantage to making yourself look bad in front of the judge, right? And we're not aware of this. It's possible there were conversations between the lawyers to maybe adjourn the appearance if you couldn't be available. It's possible. But strategically, I can't see the reason for not showing up if you're the plaintiff side. Now, that's, I guess, step one, right? I don't have the answer to that. It could be, right, in my second scenario I laid out for you, that they're getting close on settlement and they don't need to move things along with the judge. It's possible. And I guess, Jesse, before I move on to the other part of this, if the sides are working towards some type of resolution, neither side, and they think it's plausible, and making some real progress, it behooves both sides to get a discovery schedule from the judge that would set up these set dates that they have to accommodate by in the exchange of discovery and whatnot. So that would kind of put the gas pedal on the commencement of the case in real settings with the judge. So that seems to line up that defense counsel would say, hey, no big deal. Plaintiff's not here. Let's kick this out 45 days. Because alternatively, right, if there's no settlement progress and the parties aren't on the same page, if I'm accused, like Lanny Davis mentioned, of a completely frivolous case and this whole thing is defamatory, I am kicking and screaming that plaintiffs who commenced this case couldn't take the time to show up for the initial hearing. And we didn't hear that from Sharpe's side. So I think it's, again, trying to make sense of what we have here. It seems that both parties are on the same page, or else, defense counsel didn't create a clean record as to this inexcused absence from plaintiff's side, which should have been cause for concern.
I think you make a really fair analysis of what might be going on. I agree with you. You think it was interesting that the judge even said, you want to push this out more? I mean, the judge even said there seemed to be a surprise that it's not being resolved. Does that give you a sense of where the judge's head is regarding maybe what's happening behind the scenes, but also maybe the merits of the case or the substance of the case?
Well, yeah, and let's not just say it was kicked for 45 days is a long time, right? You go in front of federal judges and you ask for an extension, right? I was in court somewhat recently, and we asked for an extension of a preliminary conference, very similar to what's going on here. And the judge, federal court judge, said, no, not doing that. Come to court and explain to me why you need it kicked. So 45 days is a long period of time for the adjournment, too. It's not 7 days, it's not a week. It's not, hey, judge, we're working it, we'll come right back. Defense counsel pushing this out 45 days to make up for plaintiff's counsel not being there is also worth paying attention to. I would say maybe a week, 2 weeks, tops 30 days. 45 days gives you a signal that the parties are in no rush to proceed on this. And again, I'm just looking at what Lanny Davis, the initial counsel for Sharpe, said on here. We're going to be aggressive. We're going to file for defamation. We haven't seen those, and we don't really see a pushing of the pedal in this case. So my spider sense is going off that the parties are in some type of communication working towards resolution. Again, not confirmed, but that's what the breadcrumbs seem to say.
You think it'd be advantageous for Shannon Sharpe to settle this lawsuit after the comments that were made, after his defense, after what he's being accused of? Do you think from a legal point of view and a career point of view and a PR point of view, it would make sense to settle the case?
It's tough to say, right?
Right.
There will be a public that goes out and says any type of settlement, even if it's a no pay settlement, even if there's no admission of guilt and there's some public statement that we settled it just to move on, there will be a good portion of the public that will view this as being an admission of guilt, even if it's not. So for Sharpe's career, that's very public focused and media focused. You wouldn't recommend a settlement on a case you have no liability on. But as we know from Sharpe's side, and this was, I remember, Jesse, you and I spoke about this initially, for Sharpe's side to admit that they themselves were offering millions of dollars to settle the case, that plaintiff's side was refusing, tells you, right, that they wanted to settle this. So it's not really what I think is, or what you think is wise or unwise. Sharpe's own legal representatives are out there saying that they have had previously millions of dollars in authority to settle the case. So he kind of has to eat that fact. And this is, again, me. I didn't understand the logic behind it at the time. That type of admission that we're trying to settle this case as a 7-figure plus valuation. And shortly after that lawyer made those statements public to the world, that's when Sharpe had to step aside from ESPN. So even the entertainment of settlement seemed to distance himself from ESPN. So that's why we have very mixed messaging from Sharpe's camp as a whole. And I think what's best for his career would be to fight these tooth and nail on the merits, especially after your lawyer came out and said this was defamatory.
And think about who he's going up against, because let's talk for a second about the plaintiff's choice of attorney, which has added just another layer of intrigue to this case. We're talking about Tony Buzbee, gained national attention for representing, more than 20 women in sexual misconduct cases against NFL quarterback Deshaun Watson. He's also filed lawsuits against Sean Diddy Combs, famously pursued a then dropped case against Jay-Z that resulted in the rapper countersuing. And on his Instagram announcing the Sharpe lawsuit, Buzbee had written, "I'm extremely proud to represent Jane Doe. It takes a great deal of courage to stand up against those with power, fame, and money. I look forward to pressing this case in court." But Buzbee's absence at the July 9th hearing, seemingly without an explanation or local counsel appearing on his behalf. I mean, this is just based on what we're seeing in the reporting. Maybe there's something else going on as we're talking about. It certainly could raise eyebrows. So Dan, when you think about his involvement in this case, how does that factor everything in?
Well, it's funny you said that, right? Like, I'm looking forward to pressing this case. And again, we're talking about what Sharpe's representative said on day one, what they're doing today. Busby is saying, I'm looking forward to pressing this case. And correct me if I'm wrong, Jesse, impossible to press the case if you don't show up to court and the case gets kicked.
I didn't even need to go to New York Law School to know that. Yep.
Yeah. Yeah. Did you see my eyebrows? They're raised. They're very high. They're not like Dwayne "The Rock" Johnson raised, but they're up here. I mean, to put it bluntly, if you don't show up for court and it becomes a public record that you didn't show up to court, and you as the client are not aware that your lawyer planned not to show up for court, if there was some settlement, it is seemingly a fireable offense. Like, your job is to advance the case to get me paid, and you didn't show up. So, if Busby is off the case, right? If we see some type of substitution of counsel on the record, that would be very interesting. But the fact that we have not yet, and again, it's only been a couple of days since it happened, tells you that this was probably some coordinated effort. Again, you and I are sitting here trying to make sense of what is otherwise a barren docket on an extremely high-profile case involving one of the more high-profile plaintiffs' lawyers and one of the most high-profile sports media figures. And we have a docket that has basically no progress since April. So that, again, unless we're just dealing with an anomaly, like a pink elephant in the sports law sense, there's something cooking behind the scenes that is not certainly publicly available.
One more thing I wanted to address. I want to just talk real quick about the media fallout, the celebrity reaction. So the allegations have already impacted Sharpe's really successful media empire. Now, he temporarily stepped away from ESPN, but he continued his podcast, the popular Shay program, the Nightcap podcast. And again, this was all following the lawsuit's filing, although to be clear, no network has formally severed ties with him. And fellow sports media personality Stephen A. Smith addressed the situation in a 20-minute YouTube video titled "My Thoughts on the Shannon Sharpe Situation," calling it a sad situation. He was carefully walking the line between supporting his friend and acknowledging the seriousness of the allegations. Here's what he had to say.
It's a sad situation. Shannon Sharpe is somebody I work with a couple of days a week. Shannon Sharpe is somebody that I brought to ESPN. We've grown close as friends. I'm sincerely hopeful and prayerful that he is completely innocent of the allegations that have been levied against him. I can't sit here and speak to his innocence or guilt.
And the case also hangs over Sharpe's professional future because before the lawsuit, he was reportedly negotiating a $100 million deal for his podcast network. And those talks appear on the outset to be on hold pending resolution of the legal situation. So, Dan, when we talk about what's at stake for him here and his reputation, what are your just initial thoughts about it?
Yeah, certainly it's going to have a hit on we'll say the type of audience that would otherwise listen to Shannon, right? ESPN, nobody, again, not a secret to anybody's owned by Disney, and it shouldn't be a surprise where Disney parts ways, vis-a-vis ESPN with someone like Shannon. You could say it's temporary. You could say it's permanent. We'll figure this out. ESPN has certainly given people second chances, but the nature of these allegations are assuming they're true, assuming they're established, are very dark, and you wouldn't second guess ESPN for not bringing someone like that back. That said, in this day and age, in this media culture, Shannon has something very special, right? He has continued to produce content for the Club Shay podcast, a very successful YouTube channel. And he is seemingly, in his own way, he's become his own boss. I'm not sure if he's going to quite get the valuations he was before this dispute, but he's still garnering a very large audience on his own YouTube channel. And in this day and age, some people, again, for better or for worse, are uncancelable because they are their own boss. And if they put out content and the public still has an appetite for it, they can still exist and make money on their own channels. But for a wider distribution via Fox or NBC or an ESPN, they might not want to take a chance on an outside individual, right? Same kind of conversations that were happening with Pat McAfee once upon a time, who remains with ESPN. No stranger to controversies. They pop up every so often. But Pat is his own animal and commands his own audience. So if one day Pat got fired from ESPN, he could have his own Pat McAfee YouTube channel and I'm sure do very, very well as a complete independent. So that's what Shannon has to weigh. It's a different culture than maybe we had 20, even maybe 10 years ago, where people did not have their own channels. And Jesse, you mentioned something interesting about someone like Stephen A., right, who hasn't had the same level of controversy of a Shannon or a Pat McAfee. Stephen A., while at ESPN, is building up these own channels, be it on YouTube or on social media. So it allows maybe a larger net for someone of that status to fall and land and be their own boss. So it's a different media culture we're looking at in 2025.
Dan Lust, thanks for making sense of it. All of this, sometimes what doesn't make sense, you make sense of it for us. Thank you so much. Good seeing you. Really appreciate you taking the time.
My pleasure, Jesse. Anytime.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.